Welcome to the I Got Fired podcast, a podcast for people who've been fired or afraid that they might be. I am pleased today to be joined by Jessica Childress. Jessica is the managing attorney of the Childress firm, PLLC, an employment law firm based in Washington, D.C. Ms. Childress is representing clients in matters involving wrongful termination, retaliation, discrimination, and sexual harassment. Ms. Childress is a graduate of the University of Virginia School of Law. Well, welcome, Jessica.
Thanks for having me, Tom.
Sure. Well, listen, today what we're going to be talking about is the Worker Adjustment and Retraining Notification Act, or the WARN Act. So we're going to chat a little bit about that. So I will turn it over to you and let you tell us a little bit like what is the WARN Act and what is it for?
Sure. So we're facing an unprecedented time, Tom, as you know, and as your listeners know, we're facing just an unprecedented time with the economy, with the potential for layoffs. We've already seen layoffs happening across industries. And unfortunately, many of the people that we love, many of the people that we know will be subjected to layoffs over the course of the next several weeks and months. So the WARN Act, it's an older act. It's not new. It's not a part of the new legislation that's been coming down over the past week or so. This is an act that requires certain notifications to be given to employers who are the subject of a termination, a mass termination, or a mass layoff, as WARN describes it, or a plant closing. So right now we're going to see, unfortunately, many businesses laying off a large number of staff or closing their facilities, and this is going to trigger obligations under the WARN Act. And those obligations require that the employer give their employees who are affected by these plant closing or layoffs certain notifications. And the notification is really required 60 days in advance of the separation or the termination of employment. Now, there is an exception to the WARN Act, and that one of those exceptions, or two of those exceptions that may be applicable here, are the exceptions for unforeseen circumstances. It's arguable that COVID-19 was an unforeseen circumstance, and employers did not have any idea that their business operations would be affected in a way that requires terminations and plant closings. There's also the argument that COVID-19 constitutes a natural disaster. But we're all in this very ambiguous place because there's no legislation, there's no guidance from courts or the Department of Labor that provides guidance on the WARN Act that definitively says that a pandemic or that COVID-19 is an unforeseen circumstance or is a natural disaster. There are good arguments that this pandemic fits within both of those categories. But even with these exceptions to the 60-day notice requirement, even if COVID-19 did fit within the unforeseen circumstance or the natural disaster exception, employers would still be required to give notice as soon as possible, as soon as they knew that they would be instituting these mass layoffs or plant closings. So
Right.
that's the general overview of the WARN Act, and I can get into the specifics of what's required, Tom, but I'll let you ask any questions that you have now.
Yeah, sure. I'd love to dive in a little bit more of the specifics. But if you could give our listeners an idea of how would they know if their layoff is subject to the WARN Act?
Sure. So first of all, you have to be working for an employer that employs 100 or more employees. So if your employer is a small employer, does not employ 100 or more employees, then you're not going to be subject to your employer is not going to be subject to the WARN Act. You're also not, in that 100 employee threshold does not count part-time employees. But if your employer employs part-time employees who work a combined, and full-time employees who work a combined number of hours that exceed 4,000 hours per week, then they do meet this 100 employee threshold. So that's the first question, whether your employer is actually covered by the WARN Act. The termination or the layoff is going to have to be for 6 months or more. So if you will not have suffered an employment loss under the WARN Act unless you've suffered a termination or a layoff that exceeds 6 months. Or or you also have to have a reduction in your hours of 50% or more for each month of any 6-month period. So this is, and you also can't be terminated for a voluntary, you can't have engaged in a voluntary departure from the organization or from the employer, or retired from the employer. And you also can't be terminated for cause. So if those circumstances exist, you're going to be excluded from any rights that you may have under the WARN Act.
Got it. And is there, I think I've seen in some cases where they'll actually give you a notice, or they're supposed to give you a notice. Is that right?
Exactly. So they're supposed to give you, when they, at least 60 days if you are an effective employee. So assuming that you work for one of these employers who have 100 employees, they are instituting a mass layoff where they are terminating more than 50% of the workforce. They're supposed to give you a notice, and I'll go into exactly what that notice is supposed to say. So it's supposed to contain the following pieces of content. It's supposed to be a statement as to whether the planned action is expected to be permanent or temporary, and if the entire plan is to be closed. It's also supposed to include an expected date when the plant closing or mass layoff will commence, and the expected date when the individual employee will be separated, as well as an indication as to whether or not they're bumping rights. So as to whether or not you are entitled or someone else is entitled to take your job if you are terminated. There's also supposed to be the name and telephone number of a company official that you can contact for further information. So those pieces of content are absolutely supposed to be within your notice. And if the employer, so this is a very real situation that is likely to occur at this juncture, where we don't know, where we just haven't had, where employers haven't had enough time to prepare for this pandemic, and they can't give you 60 days notice. They're making really quick decisions on the fly, and they may have only 15 days to give you notice. They're supposed to explain why they're only giving you 15 days notice, and they're supposed to explain the basis for the exception to the WARN Act, explaining that they're supposed to give you 60 days notice, but also explaining the shortened notice period.
Let me ask you in terms of, well, two questions. I guess if an employer violates the WARN Act by failing to give notice, then I suppose you would just have to learn that by just knowing that a lot of people have been laid off, because you're obviously not getting notice in that circumstance. You just would have to suspect that they were supposed to provide that to you.
I think employees are allowed under the National Labor Relations Act to discuss the terms and conditions of employment. So in this particular situation, this is definitely an area and a time in which you should be talking to other employees about what's happening in the workplace, about whether or not they're receiving notices, whether or not there's been any discussion of layoffs. And so if you do know that your entire department is being laid off, this should trigger within you the thought that this could be a WARN Act issue. The WARN Act may be triggered. So it is, I think it's a matter, Tom, of having your eyes and ears on to the ground and your nose to the ground, and really trying to be observant of what's going on around you.
And do you know, and okay if you don't, because I frankly don't either, in order to reach the employee threshold, does that imply, how does that apply to franchisees or employers with more than one, location? Do you know how that number is counted?
It
So,
does not.
go ahead.
It doesn't include part-time employees, but in terms of franchisees, I don't know for sure. It's my hunch that it's not going to include franchisees because the employer should be the individual franchise owner, but I can't say that with 100% certainty.
That would be my guess too. I think, obviously for folks listening to this, you would want to talk to an attorney. We could do a little research on it to find out. But my guess is and it might just be also the nature of the franchisee and the franchisee franchisor agreement. There may be tests about, the level of control. I just don't know. I was just curious how that would play out. Okay, so this has been very helpful. So So let's say that I'm an employee and I think that my employer has violated, the WARN Act. What do I do? What's my recourse? What are next steps?
Sure. So one thing that I failed to mention was that if you are, I know that you, Tom, are based in Virginia and serve clients in the General District of Columbia area, the greater DC area. So Maryland has a mini WARN Act that's voluntary for employers. Most states do have their own, many states have their own version of WARN. If states don't have their own version of WARN, what is called a mini WARN Act, they just follow the federal law. So states that if there is a WARN Act violation, you should go to your state employment body. You can call the Department of Labor. You can also institute you can institute an action with your U.S. District Court. It's a federal, what's called a federal cause of action. So you can file a federal lawsuit if you are aware of a WARN violation. But of course, you should talk to an attorney who specializes in this field to assess the facts of your specific matter.
I think that's a good point too. It's not like a discrimination claim where you have to file with the EOC. You can go straight to federal court on that. Is that correct?
That's right. That's right. The District of Columbia, they have their rapid response unit, and so their representatives may be able to provide some resources, but if you do know that there has been a WARN Act violation, you have your own private cause of action.
And for those listening, the Department of Labor has a number of good resources on this, and you can find them, and we'll put this in the show notes, but it's dol.gov. And you can go there and get a lot of good resources on WARN Act. Okay, Jessica, so if I come to you, I think my employer has violated the WARN Act, I'll come to you. What are my remedies? What can I possibly get from a WARN Act lawsuit?
Sure. You can get back pay and any benefits that you are owed for the period of the violation. So if an employer gave you 1 day of notice, and they were supposed to give you 60 days of notice, assuming that there is no exception that's going to be applicable here, you can get back pay for 59 days and any benefits that are owed to you for that 59-day period. You also, if you're a prevailing party for a WARN Act violation, you can also get attorney's fees if you're a prevailing party. But we're really in a terrain that where there are a lot of ifs here. And those exceptions are pretty heavy exceptions. And there are good arguments for employers right now that one of these exceptions apply. And so employees and employers really should make sure that they're taking a look for DOL guidance, Department of Labor guidance, because it's my hunch that there will be some coming out soon to talk about this law.
Yeah, I think that's probably right. I would assume that many of these actions their strength in numbers, right? So you'd go with some kind of kind of collective action lawsuit. You'd get a number of if there's been a WARN Act, if there's been a WARN Act violation, by definition, if it happened to you, it's happened to at least 100 other people. So it would make sense to bring a group action.
Absolutely. I think there's certainly strength in numbers, also evidence in numbers here. And what's going to be very probative in this case is the number of employees who have been terminated and where these terminations have occurred, because the WARN Act is very number specific and fact specific as to where the terminations have occurred, how many hours employees have suffered reductions in hours for, and how many hours they've been reduced from the workforce. And so these are all going to be facts that are relevant in the assessment.
Got it. And I presume you don't get lost wages for the time after that. So you get, you get the lost wages for if they failed, if they gave you 1 day notice and they were supposed to give you 60, you get the 59 days of back pay, but you don't get lost wages from the 60th day forward. Is that correct? Exactly.
It's going to be until the date of termination and until the date of proposed termination.
Got it. Yeah, interesting. And I suppose I haven't seen any, but I suppose DOL hasn't said anything yet about COVID and how this is going to impact this.
Not yet, not from my research, but this is certainly a topic. The WARN Act hasn't been discussed in this level of detail amongst practitioners probably since the act was promulgated. And so I expect that there will be some guidance coming down soon from the Department of Labor to determine especially whether or not these exceptions are going to apply in this circumstance.
No, I think that's right. Any other thing anything I didn't ask you that you think would be important to know about, for folks to know about the WARN Act or how to bring a claim under the WARN Act?
I agree with you, Tom, that employees should look at the Department of Labor's guidance here. It's very well spelled out as to what the rights of employees are, and also employers who are seeking to be compliant with the WARN Act. I think it's a time that we all brush up on this act, because I think that it's going to have applicability for many people and relevance for many people as we go forward in the coming weeks.
I think that's right. Well, Jessica, I really appreciate you you joining us here today. Let people know, if somebody's trying to find you, what's the best way to do that?
Absolutely. Well, I'm at the Childress firm. You can visit my website at www.thechildressfirm.com. You can reach me. I'm based in DC. My phone number is 202-204-2200. And you can also reach me via email at jchildress@thechildressfirm.com.
Great. And you represent both employees and employers, is that correct?
I do. I represent many employees in cases such as this, WARN Act violations and wrongful termination claims, and I also represent employers with compliance issues.
Okay, great. Well, folks, if you're in the DMV area, feel free to reach out to Jessica for some good advice on this. If you're outside of our area, a good resource is the National Employment Lawyers Association. You can find them at nela.org, and there are people there who primarily focus on representing employees. And of course, as Jessica mentioned, you can, and we'll put this in the show notes as well, you can look at the Department of Labor for guidance on this. I'm sure they'll have more coming up, as Jessica suggested, and your state analog. So your state Department of Labor might have some information about, like you said, if there's a mini WARN Act at your state, that's a good place to look. But we will call it a day, and stay healthy, and good luck, Jessica. And thanks so much for joining me.
Thank you. You as well, Tom.